All right, guys, this hearing opens with the court immediately focusing on custody complications and long-term placement plans.
Okay, we actually have also, Ms. Schwartz, I want to make sure you've got on record in both files, 24-022NA is our review hearing. And I intend to take the review hearing first, but to continue to take judicial notice of the NA file for purposes of the custody file.
What was the file number again?
24-0000022
Okay, thank you.
NA.
Thanks.
Okay, so Mr. McFarland is not available to us today, having rightfully so asked for an occasional day of vacation. Mr. Fry has graciously agreed to pop in on behalf of Ms. Boker. He's had an opportunity to talk with her as well as the other attorneys and myself just briefly about some of the updates that we all look forward to hearing about today. So that being said, I look forward to your report after appearances.
Lee Heiss, lawyer guardian ad litem.
Ms. Stasia Thomas, counsel for the department. Ms. Kopis.
Eva Kopis, Child Welfare Specialist with Lenawee County DHS.
Mr. Fry.
Brian Fry, attorney for Heather Bokar for Michael McFarland.
Thank you. Ms. Boker.
Heather Boker, mother.
Thank you. I think we also have a couple of other non-respondent parents here today. Is that right? Your name?
Austin Valentino.
Okay, Austin Valentino. And then do we have Anthony Fox here?
Yes, ma'am, Anthony Fox.
Thank you. Welcome. All right. Okay. Ms. Heiss.
Thank you, Your Honor. There's also a new putative father in the courtroom too, I think, just for our records to keep track of when he joined us. I have visited with the children face to face and their needs are being met in the current placement. We have a very comprehensive planning time. And we thought we had a resolution that would help the family, but at the end, we found out there are new factors that we didn't know about. So I think at this point, we would request a review in 90 days. Mother has improved, and for 30 days, she has really shown some progress. So in addition to the fact that there isn't a legitimate a way to close on the older two boys. In addition, this gives mom more time to maybe progress towards reunification. I would request that the court release the youngest child from jurisdiction as her custody is sufficient to protect her from any risk of harm. And we have had extensive meetings about continuing the bond between the siblings. That would there'd be a division between the siblings if one were not in jurisdiction, but the other two are. So as a group, I think we're ready to recommend closing the case for the youngest and the only little girl and ask for a review in 90 days for the older two boys.
Would you recommend that we review the release of that youngest child, which would involve Mr. Valentino, before we move on to the remaining aspects of today's hearing?
Sure, yeah.
Ms. Thomas, what's your position on that?
Your Honor, we join in with Ms. Heiss and her request to terminate jurisdiction as relates to the youngest child. It is our understanding that Mr. Valentino will continue to be an agreeable individual working with the maternal grandmother to get those kiddos some sibling visits. We had a really good mediation on that point. And so I believe at this point we are ready to release that child from our jurisdiction.
So that was a custody trial wherein the father was awarded full physical, full legal custody with essentially supervised visitation. Mr. Fry, I think this is probably maybe one of the things that you may or may not have been apprised about. Have you had a chance to talk with your client about whether or not she wishes to allow the youngest child to be released from the supervision of the jurisdiction of the court in this case?
That is not something that I had an opportunity to discuss with her, Your Honor.
That's fine. Deputy, would you swear in Ms. Heather Boker?
You can remain seated, but raise your right hand, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, Ms. Boker, obviously you were here for the custody trial. You recall that. Because there is now a custody arrangement in place, it does not appear that we need to have that child as part of these proceedings anymore. Would you agree or disagree with that?
I guess I agree.
All right, very well. I do agree also. There is a custody order in place that safeguards the child and places Mr. Anthony Fox at the, oh no, that's not true. Mr. Austin Valentino, at the helm of ensuring that this child remains safe, and he's competent to do that. So we will release the youngest child, BB, born August 29th, 2021, from the jurisdiction of the court. Also releasing Mr. Valentino from being required to be here to make sure that we have updates on his child. So you're welcome to remain, Mr. Valentino, or not remain, whatever your preference is, but I wanted to answer that question for you as soon as possible. All right, Ms. Thomas, where would you like to go next?
Your Honor, just for purposes of expediency, I would ask Ms. Kopis to be sworn in.
Come on up for a witness.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
The judge directly questions the mother about releasing the youngest child from court supervision, and surprisingly, she agrees.
All right, whenever you're ready, Ms. Thomas.
Thank you, Your Honor. Ms. Kopis, you've prepared a court report for today's hearing. Are there any updates or modifications that need to be made to it?
I was informed this morning that a Blake Lewis contacted the department claiming to be the biological father of Brody. I do recognize that we have a legal father for that child, but I wanted to make the parties aware that that had come forward today.
Also, just the YouTube component. So is that the youngest child of the two, the younger?
Yes,
The youngest or the middle?
the middle, sorry, the youngest
Okay.
would be.
Middle, oh yes, middle child, youngest of the two boys. Sorry.
Yes, I apologize, the younger of the two boys.
Okay. And okay, thank you for that information. And at this point in time, just for the review, emergency planning and stuff, do you believe that there would still be a risk of harm to the children if they were to be returned to Ms. Boker's care and custody today?
I do.
And what would that risk of harm be?
Harm would be subject to physical and neglected substance abuse. The barriers that brought the children into care have not been rectified, although mother has made progress with her services, and we do commend her for that.
And at this point in time, I think one of the outstanding issues for the department has been there's effectively been a legal removal from Mr. Fox as relates to his children, correct?
Yes,
And are you still asking that the court legally release them to Mr. Fox under his under the supervision of the department?
yes, he is a non-respondent, and we do believe that he'd be willing to cooperate with us, but we would ask for it to remain jurisdiction over the children.
Generally speaking, your report indicates that there has been progress made by Ms. Boker as it relates to her case service plan. Is there any area that you believe needs continued progress or more compliance?
Parenting education is due to start shortly, so that needs to be addressed. However, that is not at Ms. Boker's fault as to why that has not been done yet. She was waitlisted. So that is the area that we'll be looking for during the next reporting period to see how well she takes advantage of those services. She does appear to be compliant with substance abuse with her peer coach as well as her counselor. I apologize, they were not part of the court report because they were provided to me afterwards, but she also provided documentation that she has been attending AA and NA meetings. And then she has not been drug screening for the department. However, she has been drug screening for probation, and she did sign a release so that we can exchange those drug screens.
And included in the report is a psychological evaluation. Have you been able to review the results and recommendations with Ms. Boker?
I have been able to review the recommendations with mother. It does appear that the case service plan supports the recommendation. There was one difference, which was it was recommending a psychiatric assessment of mother for possible medications to alleviate mental health symptoms. I have been in communication with Chris from Parkside as well as mother, and we are in the works of getting that appointment scheduled for mother.
And as it relates to parenting time, your report indicates that it's occurring, I believe, 2 evenings a week from 4 to 6 at the department. Is that correct? And is it being supervised by department personnel or by Miss Edwards or both?
Currently, it's being supervised by Ms. Linda Edwards. That will be changing once the parenting education program is in place. Ms. Edwards will have 1 day, and the parenting education will do the other visitation to support mom in her education that she's learning.
Okay. Let's see. Are you asking for any changes to the parenting time right now?
No.
Okay. And as far as the children are concerned, they effectively have continued, it seems like they've continued this standard of being at grandma's through the week for school and consistency, and then spending weekends with dad. Is that accurate?
Yes, dad also visits the home during the week as well, and to ensure that he is also taking care of the kids during the week as well.
One of the things we were charged to do after the last hearing was to have a family team meeting or mediation to discuss the possibility of a guardianship for the 2 boys. And without, breaking the rules of confidentiality for mediation, is guardianship something that the family is willing to consider at this point in time?
It was my understanding at the end of mediation that the family no longer believed that a guardianship was in the children's best interest. And we wanted to allow for more time for mother to complete her services.
Is there anything else you would like to highlight from your court report as it relates to the children, or anything from your knowledge that you believe the court should know?
Now the hearing shifts toward parenting time and the children's daily routine. The boys continue living mainly with their grandmother.
I apologize. I do believe this is my court report, and if not, again, I apologize. We do have a pending referral for the second child to see a neurologist at U of M. There was some confusion as to what contact information was needed for that referral. I have rectified that with the doctor. We are waiting for them to reach out to us.
And is there anything else?
No.
With that, then, Your Honor, I would move to admit the court report with its attachments.
I have no objection.
No objection.
Okay, thank you. They are received, the report as well as the exhibits. Questions for this witness, Mr. Fry?
Yes, how you doing today?
I'm well, thank you.
Good. So have you been monitoring Ms. Bocor during this reporting period?
I apologize. Can you repeat that?
Monitoring Ms. Bocor's progress in her case service plan this reporting period?
Have I been honoring it?
Monitoring.
Oh, I apologize. Yes, I have been monitoring her progress.
Okay. And it sounded like your testimony was that she has been doing well recently. Is that right?
I do believe that, yes, I do believe that she took to heart her recent hearings and has been willing to work with the department more and is compliant with services, yes.
Is she in currently full compliance with her case service plan?
As of right now, she's in compliance, yes.
Okay. What kinds of things are you looking to see her do in the next reporting period?
So the next reporting period, we're going to be looking for her to maintain her sobriety. We'll be looking for the outcome of that psychiatric assessment, and then as well as her parenting education, as if she's retaining information and benefiting from services.
Is the goal reunification?
Yes.
So right now, Ms. Bocor has gets to see her children supervised at the department. Is that right?
Yes.
And now you said that the children are during the week are with grandma.
That's their placement, yes.
What was that?
Yes.
Okay. And then the children's father sees them sometimes during the week as well, and then has them on the weekends. Is that right?
Yes.
Okay. Now, are is that an appropriate arrangement for the children?
At this time, it is, yes.
Okay. And is there a reason why either Miss Boker's mother or the child's father can't supervise her time?
With regards to the placement Don Gibson referring, they recently had a domestic violence, which was just dismissed. We have not had time to adequately assess whether the caregiver would be appropriate to supervise. It's definitely something we're willing to explore moving forward, which have not had the opportunity. As far as the father, I have concerns about his ability to separate his own personal relationship with mother and what the children need to be safe.
That domestic violence was dismissed, what, like over a month ago, right?
It was
Okay, and you still haven't explored that?
not at this time, no.
When do you plan on doing that?
When the professionals believe that when mother has made enough progress to move forward.
Okay. So, Miss Gibson's appropriate to watch the children, but you can't, have an opinion on whether she can also watch the children when Miss Boker's there as well? Is that what you're saying?
At this time, I believe that Ms. Boker needs a professional setting and more structure in her parenting time with the children.
Has Miss Boker been compliant with her drug screens?
She has been compliant with her drug screens with probation, yes.
And she hasn't had a violation of probation or anything in the last reporting period? Is that right?
In my understanding, in the last 30 days, she has not, yes.
Okay, I have nothing further.
Ms. Heiss?
Do you have a safety plan, a written safety plan in place for when these children are placed with the two remaining children are placed with their father? So that we can be sure that there's no risk that he will allow contact between mom and children and that he will continue this daycare schedule with grandma?
It's a safety plan that we verbally have discussed. We have not had a written plan for that.
In the event that we're back and he has allowed contact between the kids and mother or any of the things that we're not expecting, are you willing to look at a writing?
Listen carefully, because this section exposes the court's biggest concern: sobriety consistency. The department confirms the mother passed probation screens.
So that we can hold accountability?
The reason we haven't had it in writing is because we haven't placed the children there yet with him. Upon placing the children there, we would solidify a safety plan and have it signed.
Thank you so much. And then will you be sure that when you're saying the mother is complying with substance use disorder, these positive screens for THC, whose definition of sober are we using? Her counselor, her AA, or hers, or yours? But it needs to be consistent.
My understanding, when my conversations with probation is that they were giving her a grace period to allow marijuana to leave her system, and we were waiting for those screens. Although mother has signed the release just last week, I have not had an opportunity to get those screens yet to see if she is playing fully.
So we're going to use probation's definition of sobriety, which includes no THC. Is that correct?
Correct.
Thank you. Nothing further?
I just want to make sure I understand. So you would like, and I think this is what you asked me last time. So you would like me to release 2 of the children into Anthony Fox's care? Officially, but practically speaking, they would continue to stay with the grandparents 5 days a week,
They would.
including overnights.
They would.
Okay. Is there a possibility that one of these 2 children is not the child of Mr. Fox?
Yes.
And what is your plan to investigate, clarify, or inquire into that?
It was my understanding that we had a legal father, and that the biological father needed to hire an attorney and to file his own proceedings. We do have a legal father who is very attached and bonded to this child, who has provided and cared for him through all of these years, and I do believe would sufficiently continue to take care of him.
But this is one of the children that's staying with grandparents 5 and 7 days a week, right?
Yes,
But it's also the child who has the most needs.
yes.
Quick follow-up redirect, Ms. Thomas,
No, Your Honor.
Mr. Fry.
How old is this child that you're talking about?
7?
He's 5.
He's 5. Thank you.
So the child's too old for the Paternity Act to come into play anyway?
Objection, Your
Objection,
Honor. I
she's
think
not
that's a
an
legal
attorney.
question.
I think she would have told us she doesn't know how to answer that question, Mr. Fry.
That's fine, nothing further.
At the time that the affidavit of parentage was signed for this child in question, both the bio mom and bio dad knew it was impossible for them to be, for this, Mr. Fox to be the bio dad of this child. Is that what they told you?
Yes, both parents have independently told me that they are aware that the second child is not Mr. Fox's, and that they did so knowing when they signed the affidavit of parentage.
Okay, and then if the judge were to order a DNA test today for Mr. Lewis, if he wants to participate, would you be opposed to that?
We would be happy to cooperate with that.
Thank you, nothing further.
Thank you for your testimony. May you return to your seat.
Thank you.
Your next witness, Ms. Thomas, if any.
I have none, Your Honor.
Mr. Fry,
None, Your Honor.
Ms. Huss.
No witnesses, thank you.
All right, comments in closing, Ms. Thomas?
Thank you, Your Honor. As you know, our request is to effectively place the two children with their legal father, who is a non-respondent, Mr. Fox, under the supervision of the department. Primarily, policy-wise, Mr. Fox was not a respondent parent. And as I was reviewing our records, I don't believe that we had an established custody order at the time that we started these proceedings. And so I believe for those reasons, we had a removal order because custody needed to be established. I believe that that's in the works. Obviously, they have a pending trial. And Mr. Fox has the legal responsibility at this point to ensure that his children remain in a safe environment. I think that the family has been working together to ensure that all of the children's needs are being met. Mr. Fox is very realistic about his work schedule and what that would mean for the children if they were staying the night at his house 7 days a week. Grandma and him seem to have a very good working relationship and are pretty close there. So we are asking the court to consider that. Additionally, as it relates to mom, there's been some progress made. Obviously, this review period in the last month or so, which has been wonderful. And we are hopeful that she'll continue to make progress towards reunification, pending the outcome of the custody matter. And so we would ask for that 90-day review. At this time, Your Honor, I would leave it to the court's discretion and the recommendation of the LJL regarding DNA testing for the middle child or the younger of the two boys that are still under jurisdiction. The child does have a legal father who has and is continuing to provide for him. And unfortunately, I think, as Mr. Fry was going to point out, the statute of limitations or the how long a parent has to intervene through a ROPA action has passed at this time. And I know that one of the considerations is the bond between the parents there, and this child is very bonded to Mr. Fox. And so
The department strongly opposes relaxing parenting time restrictions too early. Officials warn that psychological evaluations still show high risks connected to abuse and neglect.
I'm not inclined to ask the court to order that DNA testing. But I will, again, obviously respect whatever the court decides on that point. I know that as it relates to parenting time, I know that Mr. Fry may make an argument regarding the supervision and who can supervise. So I want to also point out that the psychological has indicated there's a high risk for continued abuse and neglect of these kiddos until mom has made more progress. And I think that's really relevant here as we determine how to move forward in parenting time. the recommendation is to have structured supervised parenting time. I think that 2 times a week, one by Miss Edwards and one through the parent education service would be sufficient. And as those services continue to progress and be completed, that we could move into maybe a more familial setting for those kiddos. But again, obviously the domestic violence that was made towards grandma is concerning. And so we just want to ensure that there's stabilization and long-term stabilization on that point before recommending any other supervisors other than professionals. Thank you.
Comments, Mr. Fry?
Yes, Your Honor. So as far as any paternity issues, I don't think the court should act on anything regarding that. As the court's aware, the Revocation of Paternity Act gives a parent until the age of 3 to come forward. We're over double that, it sounds like, at this point. Way outside the time frame allowed by statute. So the court couldn't even change paternity even if they wanted to at this point. So, there's no point in confusing everybody and wasting time with the DNA test at this point, from what I'm hearing. In this case, there's already a legal father who has been, caring for the children and has stepped up for their whole lives, from what I can tell. So on that issue, I think it's already settled. As far as my client, it sounds like she has been doing well in this reporting period. I didn't hear any negatives about her from during the testimony. It sounds like she's doing everything that they are wanting her to do, and the additional piece of this education class, hasn't been available to her yet, but it should be coming available soon, so she'll be able to do that as well. But other than that, it sounds like she's been doing very well. So hopefully that will continue. We would agree with a review period being scheduled. That does sound appropriate from what I've heard, as the goal it continues to be reunification, which we also support and agree with. However, we would ask for a change in the parenting time. I don't know why a dismissed domestic violence charge is being used as an excuse to prevent my client having her mother do the supervision. It was dismissed, which means my client wasn't found to have committed that act. I'm actually familiar with that because I represented her on that case. So again, it was dismissed. She wasn't guilty of that. That shouldn't be used as a justification, and an assumption made that she actually was guilty, which seems to be what some people are making at this hearing. So to me, it would be appropriate to allow Ms. Gibson to be a supervisor potentially as well as the department, and maybe add another day of supervision where Ms. Gibson can do that, as long as my client continues on the trajectory that she is right now. But again, it was all positives from what I was hearing today. She's in full compliance. That does seem like an appropriate step at this time, is to allow Ms. Gibson to also supervise, maybe additional day for that to happen, so the department can still be involved. Ms. Edwards can still be involved as well. Thank you.
Ms. Heiss, any comments?
Your Honor, yes, I would ask you to consider that the psychological evaluation does recommend that visitation should continue to be structured and supervised by the Department of Health and Human Services or its approved designee. It will be important that she's consistent, maintain appropriate boundaries, and respond empathetically to her children. The court report shows us that she attended like 7 out of 23 visits. I believe this is not an appropriate time to move to unsupervised visits. She's doing well at this point, and we want to continue that. With respect to the second child, the parents are admitting that they created a false narrative ever since the affidavit of parentage, and that they knowingly decided that this child would grow up understanding that these were his parents. The child has a right at this point, because the mother's parenting is in question, we have jurisdiction here. We need to know if this child has Native American history, for example. He has a right to know that.
The guardian ad litem raises another explosive issue by accusing the parents of knowingly creating a false paternity narrative for years.
In this case, placing with dad of the older two boys is going to make it so grandma is not the foster parent. She's now the babysitter. So the funding stream will be different. I thought it was beneficial to the family to have an extra stream of income coming in, but the family has met. They've decided that although when the youngest one went home with dad and now she's not in daycare with grandma anymore, there isn't a need to protect the older two because the father of those legal father of those older two is reliable. So I would ask you to consider that when Heather starts to plan together with Anthony, her low score brings his high score down. So they're expecting to grow their family and expecting to plan together for these children. And because of that, a custody order cannot protect these older two children, as it would be nice to let the family go from jurisdiction. However, I would request another review in 90 days. Thank you.
Thank you. The court finds all interested parties are given notice for purposes of today's review hearing. It's also a permanency planning hearing, given the age of the case, but the goal is reunification that was subject to review today. The court finds that the goal of reunification is appropriate, should remain in place. I also find that it's early for me to release jurisdiction, even though I am going to grant a request to officially place the two younger children with their legal father at this point, Anthony Fox. And I'll address more of that in a moment. But I do find reasonable efforts towards reunification have been made spearheaded by Ms. Kopis, as well as exploration of those permanency planning goals as ordered by the court. So thank you, Ms. Kopis, for spearheading that. Thank you also to Ms. Heiss. You are certainly in satisfaction of your obligations. And I do tend to agree with you. I have a little more flexibility even than the statute allows me, Mr. Fry, in order to move and understand and explore the best interests of children in this case. So I am going to direct the department to offer the DNA testing for the middle child and the potential putative father. And that is because of some of the developments that I've seen here. So I'm also signaling to Mr. Fox and Ms. Boker here that I am very well aware that you're planning together, as sometimes it's described, and that Ms. Boker is still at the beginning of showing us her efforts towards reunification. So if it becomes a situation, frankly, where we have to look at removing from Mr. Fox because Ms. Boker is not making her progress or because Mr. Fox is not able to protect his children, then it's important to have a full understanding of what the options are, especially for the child who is literally at the highest needs of any of them concerned by the court's jurisdiction. So I'm not obviously ordering anything at this point other than just the DNA testing in order to make sure that that's really foreclosing off any potential risk here. Ms. Boker did show us that she's willing to give it a go on the case services, which is great. But the children have been removed from her care since February 20th of 2024. That's a long time when you're all under 10 and they're very little and they need permanency and stability. So we'll continue looking at the case for purposes of permanency and progress as we move forward, even understanding that technically speaking, all three of the children currently concerned by the court's jurisdiction have been reunified. Again, I am releasing the youngest child to the care and custody of Mr. Vallicino. That's reflected in today's court order. The children of Mr. Fox will be released to his care, but under the supervision and jurisdiction of the court moving forward. For the reasons the court's expressed, as well as the testimony and the information in the court report, which documents that although Heather Boker is making some efforts, and we appreciate that, she's still at the outset of those efforts and will need to demonstrate a sustained period of sobriety, dedication to her children's needs over her own challenges. And we're looking for her to continue to stabilize on housing and employment and to show us that period of stability and continued cooperation. That psychiatric piece hopefully will be another support coming in soon, and some parenting education in order to make her the best parent that she could be even if that means that it's a custody and parenting time arrangement. But again, we're clearly up in the air as far as the relationship between Mr. Fox and Ms. Boker, with some developments on that point as well. So that's where the kids will be in the next report period, and we'll come back together to look at this case on January 7th at 2:30 p.m. Thank you again to Mr. Fry for stepping in on behalf of Ms. Boker today. And unless there's any questions, that's all for today.
Thank you.
The judge finally delivers the ruling and makes it clear this family is nowhere near finished with court oversight. DNA testing gets approved. Reunification technically stays alive. But the judge warns both parents that any future instability could immediately place these children back in danger again.